that is not the determining factor whether you use a trust. Is net worth has very little to do with it in the end. It's really more of a, things we'll discuss today too, is why you might want to use a trust over a will. So with that, there's a couple kind of key things that we'll talk about with how wills work, how trusts work, as well as some of our upcoming topics as well. So welcome everybody. I'm attorney Justin Randall with Hooper Law Office. Just a reminder before I get started here, if you're participating on Zoom, you can ask questions. So there's a Q&A function that will allow me to see any questions that come up. Please feel free to ask away. You don't have to wait until the end. I will see them come up as I'm going through the presentation. So if you have questions, please feel free to ask. If you for some reason don't want to ask questions now, or you at the end of this determine you'd like to set up a time to come in and talk to one of us, we will be sending out a feedback form that gives you a place to fill out whether or not you would like us to reach out to you for an initial consultation. Those initial consultations are complimentary. They don't cost you anything to come in and talk to us. The big thing with that is it's hard to really know what sort of estate plan is right for somebody without actually talking to them first. So we don't want people afraid to come in and have that initial conversation with us. The other thing is we do schedule them for about 2 hours, but sometimes they take longer. Sometimes they don't take that long. It really depends on the conversation, on the complexity of your situation, and obviously we're respectful of your time as well. So if for some reason you have to have a shorter one, that's, you don't have to stay for the 2 hours if you have things that you have scheduled around. Okay, so like I mentioned earlier, our topic today is wills versus trusts. Sort of the big question of estate planning for a lot of people, I think, is, well, which one is right for me, and which one really do I need to even look at based off of my situation? Some people come in with a sort of a preconceived notion of the difference between the two, or when one is right for one person versus another. And some of this can be due to, unfortunately, Googling things and maybe looking at some article out there that is not necessarily either entirely accurate or just is maybe that person's opinion on it too. So what you really need to do whenever you have this question for yourself is really talk to an attorney who only practices in the area of estate planning, something that they focus on. Because if, the problem is just like a lot of careers, a lot of professions, if you're not talking to someone who really focuses in one area, you may not be getting the most specialized advice then, or the most focused advice. I mean, it's hard to focus on everything, right? Okay, so really, one of the first questions we get, and I know this is not a wills versus trust topic directly, but you'll see how this plays in. One of the first questions we get a lot of times is, okay, if I'm named as somebody's financial power of attorney, I was able to pay their bills for them during their lifetime, they became incapacitated, or they did need me to step in, so I started acting in that role. So I was paying mom or dad's bills. Can I continue doing that as that power of attorney after they pass away? And the answer to that question is unfortunately no. So powers of attorney end at death, meaning that if you were a financial power of attorney for somebody, you were their acting agent, you don't have that authority to continue on in that role anymore after they've passed away. If you said, I went down to the bank and said, well, my mom passed away and I'm the power of attorney, I need to start paying bills, they would say, I'm sorry, we can't help you. That's not the right, you don't have the authority anymore to do that. So people then ask, well, what do we do after that? How do we get the authority to continue acting sort of as that financial representative, in this case, for the estate rather than the individual? And that is where a will or a trust will really come in at that point for that individual. Is, are they named either as a personal representative in a will, or are they named as a trustee of a trust or successor trustee of a trust? If they are a personal representative in a will, or the acting trustee at that point of the trust, then they may have the authority to act. It depends on what order they're in, and on the will side of things, has the will been submitted to probate? So this is a really common misconception with wills that people have is, oh, probate's only for people with no plan. It's only for people who never got a will in place, who don't have beneficiary designations, kind of never did anything. That's who probate's for, right? And the answer to that is no, actually. Wills only direct assets that go through probate, and they only control the handling of an estate in the probate process. So if for some reason somebody is named as a personal representative in a will, but they never submit the will to probate, they're never going to be actually officially acting in that capacity. So in order to start acting as a personal representative in a will, or by the way, personal representative, you may have heard of it referred to as executor. It's the same thing. It's just what Wisconsin calls it. And a lot of states are, I've seen, started calling it that as well. So if you're named as a personal representative, well, you submit the will to probate, and then they have to approve you in that role. So really, when you're naming someone as a personal representative in your estate plan as part of your will, all you're really doing is suggesting to the court that that's who they approve. And they weigh that very heavily. I mean, without a good reason to say, no, we're not going to appoint that person, they will appoint them. But they need to give all of the interested parties for that will notice that that person is named as the personal representative, so that if somebody wants to object to that role, they can say that person's unfit. They have a period of time to come forward for that. So just because you are named as a personal representative in a will does not mean taking the will down to the bank is going to actually give you that authority to act. You do need what they call a domiciliary letter from the probate court to say, yep, I have been actually officially approved in my role as personal representative. And this process can take a couple weeks, right? I mean, it's not an immediate thing. So this is where that kind of transition from financial power of attorney agent to personal representative, there can be some delay. And that's not necessarily always a bad thing. I mean, it just sort of is what it is, right? You can't avoid it. But thinking that just taking the will down to the probate or down to the bank, for example, and hey, I'm going to start doing all of this, that's not how it works. Wills have to follow what the process for going through probate. So this can be a huge concern to people with wills who may have not understood how these really function. A lot of people think, oh, if I have a will, I'm good. Not going to go through probate. But then when they find out that that's not the case, they really want to try to avoid probate at all costs. And not to harp on probate, because there are very valid reasons somebody might actually want to go through probate for their estate. It just depends ultimately on your plan. But people tend to want to avoid probate because they've heard horror stories about how long it takes, the cost associated with going through probate, sort of the difficulties of it. And it's true. I mean, it does take about a year to a year and a half to actually really complete a probate on average. I mean, it can be sometimes shorter than that. It can sometimes be on the longer side, depending on the situation. That's sort of just an average. But it's a longer period of time than most people are expecting. And people, when they're grieving in particular, they're just trying to get all of this done, right? They don't want to take forever to finally wrap things up. But there's timelines and timeframes that somebody has to follow when they're going through probate. So the length of time is a big reason people try to avoid it, but another is cost. This is another statistic where there's really this is not an definite, this is what it would cost somebody, because it really depends more on the complexity of the situation, what the attorney's fees are, the value of the estate. But on average, you kind of see somewhere between 3 and 5% of the value of the estate is the cost of going through probate. So to give you a number example for that, if somebody had $1 million probate estate, that would be anywhere from a $30,000 to a $50,000 probate, right? That's expensive. So the cost and time associated with probate are reasons people really don't want to go through probate, or the most common reasons that at least I hear people saying, hey, I don't want to deal with that, or I don't want my family to deal with that. Another can be that probate is actually public record. So depending on how much you value the privacy of your estate, if you have people in that estate plan you're trying to protect from sort of the unsavory actors saying, oh, I see somebody just inherited money, let me go tell them how to invest it. If you value that privacy, probate may not be the right avenue to take, because somebody can go down to, receive the public records of that probate. They can request records of it, meaning they can see the value of the probate estate. They can see, the will itself. I mean, there's a lot of things in there that are open to the public then. I mean, they don't just post this. It's not saying, hey, look at John Smith passed away, look at his will, but they can come down to the probate or to the courthouse, to the county office, and take a look at it if they do request those records. So privacy, if that's a concern, probate is definitely not the right tool for you to use for your estate plan. But why would you want to go through probate? What are the reasons for that? Well, one, if you have minor children, you actually have to name guardians in a will. So you can't name a guardian in a trust and have it be actually a legally valid nomination for a guardian. It has to be done in a will. So even if all of your estate in terms of assets avoids probate, you may still need to have a will submitted to the probate court so that they can approve the guardians for your minor children. And just like the personal representative, this is something that you're really nominating, but not actually mandating it must be these people, which is part of the reason the court wants to approve them. They want to make sure that they are fit to take care of a child and that there's not any reason to be concerned. So minor children is one of the main reasons that somebody would probably actually intend for some portion of their estate plan to involve probate. Second reason, a really less common, but still common enough reason, is somebody might have what's called a deficit estate. So a deficit estate is sort of like your estate is filing for bankruptcy, is how I think about it. So when you go through probate, you have to make notice to the creditors. And if you owe, or if your estate owes more than you have in your estate, well, the creditors can take what they can get in terms of priority. But they then, after all of the money is sort of eaten up by those debts, they can't attach any other liens. There's nothing left for them. So it's sort of like those claims at that point are absolved, whatever may be over the value of the estate. So it's obviously not ideal for someone to be in that situation. You never want to have that happen if you can avoid it, but sometimes it does. I mean, there's a lot of reasons it does, whether it's due to medical expenses or whatever, right? So if that's the case though, and you've named someone as your personal representative, you want them to be able to use that probate process to actually properly go through all of the procedures for that, so that nobody can come after them later and say, well, they didn't actually follow the rules, so we're going to go after them. You want to make sure that you're absolving them of liability and making sure that they do everything properly so that they don't have that liability. Okay, so those are two big reasons that you want to go through probate, or at least some portion of your plan would involve probate. Another really big one that we see more and more often now is somebody has specific provisions in their will that are very important to follow in order for their estate plan to be actually successful. So a lot of times, for example, there is, when it comes to long-term care planning, there might be a certain type of spousal supplemental needs trust for the surviving spouse in that will. And that's one of the only, or under the rules in Wisconsin, that is one of the only exceptions we have to not causing a problem for the surviving spouse having to spend down certain types of assets when they're in care. Well, we need the will to be submitted to probate then in order for that supplemental needs trust to be set up, because that's where those terms are dictated. Just having them in the will, but never actually having those provisions set up and approved by the court means that it's basically worthless because it never actually came into effect. This can also apply though to maybe somebody who has a child with special needs, right? If there's a special needs trust that needs to be set up and there's provisions for that trust in the will, and it's really important that that child not lose access to certain benefits because of the care they're getting from those like caregivers, or maybe the social programs they're a part of that are a part of that benefit. A lot of these benefits are means tested. So if that child just receives an influx of assets into their own name, that would potentially or very likely cause them to lose, or at least temporarily disrupt, their benefits. So having a supplemental needs trust or a special needs trust set up through your will means that if you want that to actually work and come into play later, you have to expect to use some level of probate in order to get that done. So what if, none of those situations are really a concern for you? You're just trying to avoid probate, no minor kids, everyone's healthy, there's no disabilities, there's no children with special needs, no long-term care considerations, just kind of standard, all our kids are out of the house and we're just trying to get our estate plan in place, right? Or in order or up to date. But the main goal then being, hey, I want to avoid probate because I've heard a lot of bad things about it, right? I've heard all of these horror stories about what can happen with probate, the costs, the time, all of that. A lot of times people come in and say, well, don't beneficiary designations avoid probate? So I can just put payable on death or transfer on death on my bank account or my IRA and, all of that, and avoid probate and make sure that, nothing goes through probate and everything's all fine and, as simple as possible, right? Well, unfortunately, that is another huge misconception. And it's not because beneficiary designations don't avoid probate. They do avoid probate. But the problem is they're not by themselves really a plan. They are tools to use in a plan. And we often do use payable on death or transfer on death as part of someone's estate plan. But it is not by itself a plan. One of the big reasons it can cause problems is those designations are on every account. They're not one central controlling document. So at least with a will, there's one document you have that if everything is funneling through probate, or at least a sizable or major portion of the estate is going through probate, the will is that central document that controls everything at that point. But with every different account having a beneficiary designation on it, and that's the only plan that somebody has in that circumstance, that is, maybe dozens of different controlling documents at that point. So it's not a central control for the person handling your estate to deal with. Another big problem is that if you are expecting your will to actually control things, but the beneficiary designations conflict in any way, the beneficiary designations are what are going to actually dictate what happens. They will override the will on certain aspects of your plan. So if, maybe one of the most common examples of this would be, for example, that we have the home going through probate because they don't have a beneficiary designation on it. But then maybe the home's only worth $150,000, but they have this investment account worth $1 million, and they leave the $1 million account payable on death to the personal representative so that they can pay expenses and do whatever they, think that they need to do for probate. Well, the only thing getting controlled, say in this will, and in this example, let's say it's 50% to each child. Well, the only thing actually that legally has to go by the terms of that will is the home, because the home is the only thing that went through probate then. Things can go wrong here because maybe the personal representative is one of the kids, but maybe they're not one of the children at all. Maybe it's a family friend that you really trust to run these sorts of things for you. Well, once the person that is the beneficiary receives those funds, they are the owner of them now. So they are under no obligation to follow the terms of the will at that point if they received the money as a beneficiary themselves. They are under no obligation to use that for the expenses of the estate. So if you were anticipating them to use that for that, they don't actually have to as personal representative anyway, because they individually became the owner. But the other problem too is, let's say that personal representative is one of the 50% beneficiaries. Well, if you left everything to them and they're under no obligation to share it anymore, then did your estate plan really get split up 50%, 50%, or did one person only get 50% of one asset and the other person got the big chunk of everything else because of how you designated it? And this happens, unfortunately, and it's not because of anybody really trying to do anything wrong. It's trying to be efficient, but unfortunately not understanding how that process really works. Another huge concern with beneficiary designations, and this is really often overlooked, is what if one of those beneficiaries who is on there ever develops a substance abuse issue or develops a disability, or maybe you knew about the disability, but you didn't know that you had to be aware of certain things, in terms of means tested programs, or what happens if that person gets sued or divorced. I mean, basically anything that happens to somebody, what happens, what then happens to that money that they're receiving. And if they're the direct beneficiary on an account, that just means it happens to that money potentially as well. So, I mean, there are some protections for things like divorce on inheritance, but that's only some in Wisconsin anyway, because of the marital property laws. But one of the big concerns is people don't tend to keep those assets separate after that point with their spouse, and they will commingle them accidentally. And then it becomes very difficult to tell which account or what assets are actually individual inherited property at that point. So, but anything that happens to a direct beneficiary also can happen to that money then. So if somebody in particular, it was an unforeseen thing, like they did develop a disability of some kind, or they were they're now unable to work going forward, and you couldn't have foreseen it, or they you were named a grandchild or a granddaughter on your account, but did not foresee that they would develop a substance abuse issue, and they just received that money as an adult. Well, that can cause a lot of problems, because beneficiary designations by themselves don't have triggering provisions generally that would say something like, oh, if they are a child with special needs who is on any sort of means tested program, or they have a disability of some kind, or they have a substance abuse issue, here's how we manage it for them so that they don't lose access to certain benefits or cause harm to themselves in the case of the substance abuse issue. A will would have provisions like that, but beneficiary designations by themselves don't. So that's the sort of thing that can really go wrong with beneficiary designations. I mean, the paying of sort of expenses for the personal representative, expecting it to be used by that, yes, that's still not a good way to do that. But my bigger concern would be causing harm to somebody who may or may not be able to hold assets in their own name because of certain types of benefits that they're receiving. So if you do want to avoid probate then, but you still want to have the planning in place for all of those contingencies, what happens if somebody does have a disability or they do have a substance abuse concern, how do we plan for that, but still, avoid probate? And how do we have that central point of control for everyone to handle the estate and avoid probate? And that's really where the trusts come in. So, the most common type of trust you've probably heard of is what's sometimes referred to as a living trust, a revocable trust. I mean, there's literally thousands of types of trusts out there, but really the most common one we would be talking about in this instance is a revocable trust for avoiding probate as the main goal. So what a trust really is a way for you to hold that property while you're alive. You have certain things titled in it or beneficiary designated to it, so that if you become incapacitated or you pass away, there's a successor in place to manage those things for you. So a successor trustee, as I sort of alluded to earlier, is somewhat similar to a personal representative in kind of what their role is. It just depends on which document they're named in. So if you are the trustee or successor trustee of someone's trust after they've passed away, well, that's sort of like being the executor of the trust. The difference is that unlike in a personal representative capacity where you have to submit the will to probate and be approved and all of that, if somebody's named as a successor trustee for the person who passed away, well, they just are automatically that trustee. They are already pre-approved, so to speak, by the person who drafted that document and whose estate plan it is. So there's way less of that waiting period for, when can I start acting? I mean, it's still usually a good idea to update what's called the certification of trust so that somebody is actually listed now as the acting trustee, so that if they have to go to the bank, there's no concern, but there's no court approval for that because there's no court involvement in trust administration. So with that, it's a much quicker transition. So oftentimes it's the same person as the financial power of attorney, just like it often is in in the personal representative capacity, but this is a much quicker succession at that point. You're not waiting to be approved. You've just been approved. You've already been named in that capacity. So Quicker on that, but it's also a huge benefit of a trust is the privacy aspect of it. So I mentioned that probate is public. It's somebody could request records or, see the financials of the estate, and that may not be what you want, but they cannot do that same thing with, with a trust, for example. So trusts are much more private because they are not public record, but there's also generally protections in that trust of, who can actually request information from the trust. So it's usually limited to, certain beneficiaries. Maybe they can only see certain aspects of their own, inheritance, but can't request to see what, cousin Sue is getting, or, see what everyone else is getting and then get upset about it. So there's some more privacy protections for your wishes, saying that, nobody can really get upset about this because they can only see what they're getting. Now, if you leave them like $1, they might still be upset about that. But generally, it's just better to not leave them $1, because now that if they're left anything, now they're entitled to certain information. So, the avoidance of probate is really a huge benefit of using a trust. Having the sort of quicker succession into that role is really nice. But it's also the privacy, like I mentioned, and then there are contingencies in that plan for what happens if somebody who is a beneficiary of that trust, if they have any reason that the kind of large influx of money would cause any sort of problem, right? If it is a means tested benefit, something like Medicaid, for example, or, sometimes certain types of like benefits for children with special needs, those are the big concerns there. But, maybe you want to plan for a grandchild who was very young, like I mentioned, when you first set it up, or maybe you left it to a son or a daughter, but then they passed before you, and now one of their children has a substance abuse issue that you did not foresee. Those are the types of things that in a will or a trust, they would say things like, okay, well, here's how they have to inherit then, or here's the types of restrictions we're placing on it so that it can't cause them any harm, or they can't use the money to cause themselves harm, and somebody else has to manage it for them in the meantime. So these can be both done in a will or a trust. I mean, these are very common types of provisions that you would want in either of those, quite frankly. But if your goal is to avoid probate and still have all of those protections, that's where a trust is going to come in more so than a will would, in terms of having that central controlling document, because one is a perfectly valid will is a perfectly valid tool to use if you are intending to go through probate, but it is a trust that you would want to look at instead, more likely, if you had any reason, or if you had no reason whatsoever to go through probate and just thought, yeah, I really should avoid it. It's too expensive. The time commitment is too long, and I have no reason, no minor children, no deficit estate issues, no reason to actually go through probate. So with just a couple minutes left here, I want to kind of plug our next couple webinars here. So we are not going to have one next week, with the holiday and all of that, but the week following that and then the week after that are sort of a two-part series of sort of maintaining control over your care. So what we'll be talking about in 2 weeks then is planning for care before you are receiving care, before you need it, to maintain control of things as somebody may be aging or needing to look at long-term care. And then the week after that will be, how do you protect things, or how do you plan for that protection after someone's already started receiving that care? So with that, I'll just leave you with one quick reminder of, please feel free to fill out those evaluation forms and let us know if you'd like us to reach out to you to set up a time to talk to one of us. Otherwise, we will see you guys in 2 weeks from now, and I hope you guys have a great 4th.